The campaign for freedom of expression, Media Monitoring Africa and South African National Editors Forum have welcomed the judgment by the South Gauteng High Court to dismiss the Moti Group's bid to silence journalists at amaBhungane. Deputy President, Judge President Ronald Sutherland ruled that the amaBhungane journalists can continue to publish their series on the Moti Group, and they do not have to return the leaked Moti documents or identify their source. Media Monitoring Africa Director William Bird joins us now via Zoom for more. Very good evening to you, Mr. Bird. Thanks for joining us here on SABC News.
Good evening. Thanks for having me on the program.
You're most welcome. All right. Of course, you have welcomed this judgment, but let's talk about, what this ruling means, not only for you as an organization and your affiliates, but for media freedom, more importantly.
Well, it's really significant because what it does is it smacks down a very clear effort that was being made to try and muzzle the media. So if you look at the basic facts of it, what happened is the Moti Group went and they got what was called an ex parte order, which is a pretty exceptional thing to do, which is effectively they went to court. amaBhungane were not given the rights to even be there or to reply, and it took place in camera. And that order said you have to give us back our materials, and it said you can't report on us based on that data any further. And what the judge found today was that basically that was an egregious abuse of the court process of that particular thing of an order. And then the judge also set out quite why this is such a problem for a democratic country. And in doing that, it really does once again highlight the critical role that media plays in a democracy.
Part of what they'd put across, the Moti Group, was a violation of privacy. Care to take us through, some of, the arguments that were then put forward? I mean, pre the ex parte order. I'm talking now, as of course you then had to argue the case. What was put forward and argued by the legal team?
So, I mean, their argument was that amaBhungane had got hold of documents which they assert had been stolen. So amaBhungane had not released the name of the source. The Moti Group said that it was coming from a particular person who had stolen them, and that because they'd been stolen, amaBhungane was then effectively in possession of stolen materials, and they argued that they were effectively an accessory. So because they had stolen materials, they said, you've got these things, they're stolen, we want you to give them back. And it included, they said, a whole lot of confidential information, et cetera, et cetera. And at the time, that wasn't made clear what that information entailed. They also then said that this reporting was defamatory, and that therefore they had to stop reporting any other further on the basis of that data. And so while there is certainly an argument about privacy and the lines that the media can and shouldn't cross, particularly when you're dealing with personal data, that wasn't actually what this case was about. They tried to make that was what the case was about, but really what this was a case of bullying and attempting to silence media by going and getting this very particular order to stop them from reporting. Because had they gone and tried through the normal process, as was seen in the way that the case was actually argued, they would never have been given that kind of order, or indeed an order stopping them from publishing the material.
Yeah, and it seems you anticipated my next question, because I wanted to talk about, when there are rights, you also have to balance it out with, responsibility. So we can certainly talk about the right to press freedom, the right of the press to express itself and so forth and to publish. But what is the responsibility then of the media at large when it comes to that balance that you just touched on there, which is, of course, that right to freedom of speech and so forth, but also the right to an individual's privacy or company's privacy? I mean, how do we kind of balance that out?
Well, again, that's an interesting kind of argument and a fallacy that has been used on social media to say, the media just think they're a law unto themselves and they can do and say whatever they like, which of course is not true. So for SABC, for example, you have extensive editorial policies that dictate that you can't just publish anything that you like. And if you do publish anything that you like, where you haven't sought to balance those rights and you do publish, for example, personal information that has got no public interest in the people knowing it, then that would be an egregious breach of your code. People could be disciplined. In the worst case scenario, the ICASA could withdraw or impact the license conditions or certainly sanction the SABC. So there are a lot of very real consequences that determine that in the ordinary running of things, news organizations have to make that balance every single day.
Yeah.
Sometimes, of course, they get that wrong. We consistently highlight when, for example, media identify a child when they really shouldn't, and it's not in the best interest of the child for them to be identified, and that's something that happens on a daily basis. In this case, you're talking about media saying, is there a public interest in the public knowing about this kind of information? Does it potentially expose wrongdoing? Does it expose corruptions or actions by public or private entities that the public have a right to know about that may impact our democracy? And if they can answer yes to that, then they should probably publish that. And that's, again, certainly the case that the SABC has to adhere to as well, as indeed every responsible journalism entity.
Yeah. I understand you admitted as Friends of the Court, and part of the argument that you had made as Friends of the Court was that it's also the court's responsibility to create an enabling environment for media. I'm just quoting here. What is that enabling environment that you had then referred to?
So that enabling environment means that journalists need to be protected and need to be allowed to do their job. So when people try and silence them through bringing this kind of bizarre action where you go without them knowing, without them having the right to reply, and without them even being allowed to be in the courtroom, it's precisely that. Courts need to make sure that they say this is how our justice system works. We need to adhere to our international and regional obligations, respecting the rights to freedom of expression and media freedom, and make sure that media can do their job in an unhindered manner. Again, it's so that people can't come and say to you as the SABC, oh, no, you can't tell this story because we don't like that person. It's to make sure that the courts then say, no, we recognize the importance of freedom of expression. It's not to say it's not a limited right, because obviously there are limitations to that, but we're not going to operate in a manner that's unhindered and in a manner that allows willy-nilly for that freedom of expression to be withdrawn.
All right, Mr. William Bird, thanks very much for giving us your time there. That is William Bird, Media Monitoring Africa Director.